Okay, getting personal knowledge out of the competence chapter. At this point, competence is facts that can be admitted and witnesses that are allowed testimony or give testimony. Personal knowledge, part B of this chapter. Almost all restrictions on competence have now been eliminated, but not all. Among the few restrictions that remain is the rule requiring that a witness testify from personal knowledge. Even this rule is relaxed for witnesses testifying as experts, a topic taken up in the next chapter. For all other witnesses, though, the personal knowledge requirement is yet another manifestation of our system's faith in via voce evidence. It works in conjunction with the hearsay rule to limit trial testimony, generally to first-hand accounts. Without the personal knowledge requirement, the hearsay rule could be easily evaded. Instead of testifying, I heard that Oliver was dealing cocaine out of his apartment, a witness could just say Oliver was dealing cocaine out of his apartment, thereby avoiding reference to any out-of-statement court statements. Conversely, the personal knowledge requirement could do little work without the hearsay rule. A witness limited to recounting his or her first-hand experience could still testify. 2 months ago, here is what happened to me. I was told by some mutual friends that Oliver was dealing cocaine out of his apartment. One problem raised by the personal knowledge requirement explored in the materials below is that deciding whether a witness has personal knowledge very often involves deciding whether to believe the witness. Suppose a witness claims to have seen the defendant fleeing the bank after it was robbed, but defense counsel suggests on cross-examination that the witness was too far away to see clearly, or worse, was nowhere near the bank the day it was robbed. Does the judge need to resolve this matter in order to determine whether the witness is competent to testify? If the answer were yes, judges would, in essence, wind up deciding whether witnesses should be believed. The job of our system generally entrusts to juries. So the personal knowledge of a witness is assessed under the sufficiency standard. All right. Advisory Committee Note to FRE 607 for Californians. It's CEC 702. The rule requiring that a witness who testifies to a fact which can be perceived by the senses must have had an opportunity to observe and must have actually observed that fact is a most pervasive manifestation of the common law insistence upon the most reliable sources of information. That's a great explanation of this rule. McCormick 10, these foundation requirements may, of course, be furnished by the testimony of the witness himself. Hence, personal knowledge is not an absolute, but may consist of what the witness thinks he knows from personal perception. It will be observed that the rule is, in fact, a specialized application of the provisions of Rule 104B on conditional relevancy. This rule does not govern the situation of a witness who testifies to a hearsay statement as such, if he has personal knowledge of the making of the statement. Rules 801 and 805 would be applicable. This rule would, however, prevent him from testifying to the subject matter of the hearsay statement, as he has no personal knowledge of it. The reference to 703 is designed to avoid any question of conflict between the present rule and the provisions of that rule, allowing an expert to express opinions based on facts of which he does not have personal knowledge. So, seeing how this applies in United States versus Hickey, should have realized I didn't read lightly. We'll get to that. This is a 1990 case in the Sixth Circuit. Circuit Judge Milburn delivered the opinion. This case involves an appeal by Quinn Hickey from his jury conviction in a drug conspiracy case. Hickey, along with 18 co-defendants, was charged with numerous counts of conspiracy to distribute cocaine in violation of federal law and use of a communication. This is the cause of action. These are some facts. Communication facility to facilitate a crime in violation of another federal law. A jury trial commenced on September 8th of 1988, and several of Hickey's co-defendants, including Bayron Moreno, were found guilty. However, the jury was unable to reach a verdict as to Hickey, and the court declared a mistrial as to him. Hickey was retried and found guilty on 1 count of conspiracy charges and 2 of the communication charges. An investigation of drug trafficking in the Saginaw, Michigan area soon centered on Jack Ventimiglia. Is a self-confessed cocaine addict, and his testimony at the trial was characterized by the district court as the words of a loose cannon. In a lengthy cross-examination, defense counsel was able to expose Ventimiglia's cocaine addiction, his claimed lack of memory, his uncertainty as to details, and several inconsistencies in his testimony. In ruling on the defendant's motion for a judgment of acquittal, the district court stated that Ventimiglia's testimony alone, so that was the motion. The district court stated that testimony alone would not support a guilty verdict. However, the district court denied the motion because the government had introduced, apart from Ventimiglia's testimony, substantial circumstantial evidence that would tend to support the fact that Hickey was in part of selling. So Hickey argues that the district court committed reversible error in allowing the jury to hear and consider the testimony of Ventimiglia. After pointing out Ventimiglia's drug addiction and inconsistencies in Ventimiglia's testimony, Hickey argues that there was a total lack of sufficient or supportive evidence to substantiate the findings that these witnesses had personal knowledge of the critical events in the prosecution upon which to base their testimony. This is not the first case in which we have faced an argument that the testimony of Jack Ventimiglia should be excluded. In U.S. v. Moreno, 1990, we rejected an argument by Hickey's co-defendant in the first trial that inconsistencies in Ventimiglia's testimony in light of his admitted drug addiction showed that he was incompetent to testify. We read that case. In Moreno, we relied on Ramirez, and that was 1989 case which recognized where the cert was denied, and which recognized that in some cases the ability of a witness might also be impaired, might be so impaired that he cannot satisfy the personal knowledge requirement of Federal Rule 602. What we did not mention in Ramirez was the fact that the threshold of 602 is low. Okay. 602 provides in relevant part that a witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Testimony should not be excluded for lack of personal knowledge unless no reasonable juror could believe that the witness had the ability and opportunity to perceive the event that he testifies about. Weinstein's evidence is the source of that information. Despite the fact that Ventimiglia's testimony may have been in large part unbelievable to some, and in spite of the possibility that his perception was sometimes impaired, a reasonable or rational juror could believe that Ventimiglia and the other prosecution witnesses perceived the course of events to which they testified. Accordingly, we hold that the district court did not abuse its discretion in permitting Ventimiglia's testimony or the testimony of the other prosecutional witnesses. The judgment of conviction is affirmed. So, this harkens back to the fact that personal knowledge of a witness is assessed under a sufficiency standard, and it's preferred that the juror makes a decision whether or not to find it credible. So the United States versus Lightly is an earlier case in an earlier section, which is just an introductory section talking about FRE 601, which is generally witnesses' mental or moral qualifications, or just qualifications in general. This is in the First Circuit of 1982. Irvin, the circuit judge, gave the opinion that on December 19th of 1979, Terrence McKinley, an inmate at Lorton Reformatory in Northern Virginia, sustained serious stab wounds from an assault in his cell. Two of McKinley's fellow inmates, Randy Lightly and Clifton McDuffie, were investigated, but only Lightly was formally charged. McDuffie was not indicted by the grand jury because a court-appointed psychiatrist found him incompetent to stand trial and criminally insane at the time of the offense. He is presently confined in a mental hospital. On May 22nd, 1980, Lightly was convicted of assault with an intent to commit murder and sentenced to 10 years imprisonment to run consecutively with the sentence he already was serving. The government's case included testimony from the victim, Terrence McKinley, inmates Harvey Boyd and Robert Thomas, and McKinley's treating physician, Dr. Lance Weaver, which indicated that McDuffie and Lightly cornered McKinley in his cell and repeatedly stabbed him with half pairs of scissors. Lightly received a severe cut on his hand in the assault. Lightly's account of the stabbing was that he was walking along cell block 3 when he saw McDuffie and McKinley fighting in McKinley's cell. Lightly said he went into the cell to stop the fight, and while he was pulling McDuffie off of McKinley, McDuffie turned around and cut him. His testimony was corroborated by 3 other inmates. The defense also attempted to have McDuffie testify. McDuffie would have testified that only he and not Lightly had assaulted McKinley. The court ruled McDuffie incompetent to testify because he had been found to be criminally insane and incompetent to stand trial, and was subject to hallucinations. We believe this was error and that Lightly is entitled to a new trial. So that's the holding. And every witness is presumed competent to testify from Federal Rule of Evidence 601, unless it can be shown that the witness does not have personal knowledge of the matters about which he is to testify, and that he does not have the capacity to recall, or that he does not understand the duty to testify truthfully. This rule applies. Okay, can't recall, duty to be truthful. Doesn't have personal knowledge. Those are kind of the only criteria these days. So this rule applies to persons considered to be insane to the same extent that it applies to other persons. And we're citing U.S. v. Lopez of 1979, Schuler v. Wainwright of 1974. In this case, the testimony of McDuffie's treating physician indicated that McDuffie had sufficient memory, that he understood the oath, and that he could communicate what he saw. The district judge chose not to conduct an in-camera examination of McDuffie. On this record, it was clearly improper for the court to disqualify McDuffie from testifying. McDuffie's potential testimony would have substantially corroborated Lightly's testimony. His disqualification from testifying, therefore, cannot be considered harmless error. In finding Lightly entitled to a new trial on this ground, we decline to rule on the other issues he raised in this appeal, reverse and remanded. So we just read Lightly, we read Hickey, and we're moving on to a new section within competence called oath or affirmation. Aside from personal knowledge, the only other general prerequisite for competence is that the witness swear an oath to tell the truth or make some similar commitment to providing honest testimony. Within limits, courts are flexible about the precise form of the commitment. One lingering controversy concerns whether the requirement that every witness take an oath or its equivalent includes a requirement that the witness understand and appreciate the oath. More specifically, there is controversy regarding whether children should be allowed to testify without some inquiry to determine whether they understand and appreciate what it means to promise to tell the truth. Another question worth keeping in mind as you read the materials below, given the general liberalization of rules of competence and given the difficulties encountered in applying the oath requirement, why is that requirement retained at all? Aside from the personal knowledge, I'm just reading this over again because I can't help but be distracted. Aside from personal knowledge, the only other general prerequisite for competence is that a witness swear under oath to tell the truth. So you're going to swear under oath if you're an adult to give honest testimony. If you're a child, you have to undergo some inquiry to determine if you understand and appreciate what it means to tell the truth. So I'm just going to write adult and child in the margin. And talk about U.S. versus Ward, a 1993 case in the Ninth Circuit. Fletcher, the circuit judge, gave the opinion. Wallace Ward appeals his conviction in 3 counts of attempt to evade income tax in violation of federal law and 3 counts of failure to file income taxes in violation of federal law. Ward is the president of I&O Publishing Company, a mail-order house and publisher located at Boulder City, Nevada. And the prosecution presented evidence at trial that despite having substantial income, neither I&O nor Ward filed tax returns or paid income taxes for these years, 83, 84, 85. On March 29th, 1990, the grand jury indicted Ward on 3 counts of each tax evasion and failure to file income tax returns. Ward chose to represent himself at trial. On July 9 of 1990, Ward filed a motion to challenge the oath, which proposed an alternative oath that replaced the word truth with the phrase fully integrated honesty. The oath would read, "Do you affirm to speak with fully integrated honesty, only with fully integrated honesty, and nothing but fully integrated honesty?" For reasons we will not attempt to explain, Ward believes that honesty is the superior to truth. Magistrate Lawrence Leavitt ruled on August 2nd of 1990, the oath or affirmation which has been administered in courts of law throughout the United States to millions of witnesses for hundreds of years should not be required to give way to the defendant's idiosyncratic distinctions between truth and honesty. That's the trial court's hold. That's the magistrate's holding. Okay. The district court overruled Ward's objections to the magistrate. All right. On August 28th, 1990, and again on October 8th, 1990, Ward pursued an interlocutory appeal of the issue. Oh my God. Which was dismissed for lack of jurisdiction. Oh my God. This is procedurally fact rich. A 3-day trial commenced on February 11th of 1991. Ward made a lengthy opening statement and actively cross-examined government witnesses. At a sidebar during the second day of trial, Ward offered to take both the standard oath and his oath. The prosecutor was amenable to the compromise, but the district court refused to allow it. "This is an oath that has been used for a very long time," the district court said, "and I am not going to establish a precedent where someone can come in and require the court to address that matter differently." At the close of the government's case on the 3rd day of trial, Ward asked once again to testify under his oath. The judge again refused, saying, "The oath has been used for a very long time. That's the oath that will be administered." Ward did not testify and presented no witnesses. Oh my God. The court's interest in administering its precise form of oath must yield towards First Amendment rights. To begin with, there is no constitutionality or statutorily required form of oath. FRE 603 requires only that a witness declare that the witness will testify truthfully by oath or affirmation administered in a form calculated to awaken the witness's conscience and impress the witness's mind with the duty to do so. The advisory committee notes that Rule 603 explains that the rule is designed to afford the flexibility required in dealing with religious adults, atheists, conscientious objectors, mental defectives, and children. Affirmation is simply a solemn undertaking to tell the truth. No special verbal formula is required. Our cases have routinely held that it is reversible error for a district court to prevent a party from testifying solely on the basis of the party's religiously based objections to the form of the oath. Who said that? A case called Gordon v. State of Ohio. Oh my God! A plaintiff in a Section 1983 action has religious objections to oath or affirmation, offering instead to say, "I understand that I must tell the truth. I agree to testify under penalty of perjury." Using First Amendment analysis requiring that government use the least restrictive means to its ends of free exercise of religion is at stake, we held that it was an abuse of discretion for the district court to insist upon the standard of the oath and to dismiss plaintiff's case for failure to present evidence. Criminal trials additionally implicate the defendant's Fifth Amendment right to testify. Moore v. U.S., per curiam, 1955. Criminal defendant with religious objections to the word solemnly in the oath must be allowed to testify. So there's all these constitutional principles that are coming up in this pro se case. Anywho, it seems like it stands on all fours with that case, and so it's reversed and remanded, but let's get through the last page of it. While oaths, including the familiar truth, whole truth, and nothing but the truth formulation date back to at least the 17th century, see Wigmore, Chadbourne, Rev. 1976, the principle that the form of the oath must be crafted in a way that is meaningful to the witness also predates our Constitution in Omicbund v. Barker of 1744. Lord Chief Judge Wills wrote, "It would be absurd for a non-Christian witness to swear according to the Christian oath, which he does not believe, and therefore out of necessity we must be allowed to swear according to his own notion of an oath." See also Atchison v. Everett, 1776, Mansfield, LCJ. As the purpose of the oath is to bind his conscience, every man of every religion should be bound by that form which he himself thinks will bind his own conscience most. This case has an odd twist in that the defendant offered to take the traditional truth oath, but only if it were permitted also to take his fully integrated honesty oath. In Ward's view, as best we can state it, only his oath expressed a commitment to the abstract purity of absolute, fully integrated honesty that must be extracted from anyone before that person's word can be relied upon. A standard truth oath was so much surplusage, distasteful wrong, but not necessarily a mortal sin to take. His own oath, superimposed on the traditional one, would have taken nothing away from the commitment to tell the truth under penalties of perjury, and indeed, in the defendant's mind, imposed upon him a higher duty. Under these circumstances, the district court clearly abuses discretion in refusing the oath and preventing the defendant's testimony. We do not have a case where the witness offers to swear only to a cleverly worded oath that creates loopholes for falsehoods or attempts to create a safe harbor for perjury, as in U.S. v. Fowler, 1979, cert denied, 1980, where the court properly refused testimony from a defendant who would not say so much as, "I state that I will tell or I will not tell a lie to stay out of jail." Ward's attempt to express a moral or ethical sense of right or wrong, Welsh U.S. 1970, coupled with the Regular Favor prevents his beliefs squarely within those safeguarded by the free exercise clause. Wow. Let's just bring in everything. Thank you. Ward also seeks to vindicate what he perceives to be his right to have all his witnesses sworn to his oath. This he cannot do. Ward has no standing to assert the First or Fifth Amendment rights of others. Ward also alleges numerous trial errors which we need not consider in light of our grant of a new trial. Reversed or remanded. And remanded. So the last case here, Allen, is a bit longer. So, do another recording. But that's on oath or affirmation as well.